This brief video will serve as a general introduction to Canada's court system. There are three branches to the Canadian government: the executive, typically called the government, the decision-making branch. It includes the monarch, as represented by the Governor-General, the Prime Minister, and the Cabinet. The legislative branch is the lawmaking branch, composed of the Senate and the elected House of Commons, and the judiciary, in other words, the court systems. In Canada, judges are appointed rather than elected, and having an independent judiciary is generally seen as being fundamental to our democratic society. There are a number of different levels of court in Canada with different functions. The Supreme Court of Canada is our final court of appeal, the highest court in the country. It's composed of 9 judges, 3 of whom must be from Quebec, and it hears appeals from all appellate courts in the country, as well as from the Federal Court of Appeal. It can also hear reference questions on constitutional matters, where, in essence, it provides its opinion, advisory only, on the important legal questions to do with particular pieces of legislation. Provincial courts of appeal are superior level courts. They are the highest courts in the particular province or territory, and they are appointed by the federal government. Provincial trial courts are also superior level courts. The names differ. For example, in Saskatchewan, we have the Court of Queen's Bench, which will be the Court of King's Bench when the monarch changes, whereas in British Columbia, they have the British Columbia Supreme Court. In some provinces, there is a single court called a Supreme Court with trial and appeal divisions. The important thing to note is that the provincial or territorial superior courts and the provincial courts of appeal are Section 96 courts because they were appointed by the federal government under Section 96 of the Constitution, and they are therefore courts of general jurisdiction, which means they can hear any legal matter except if a statute expressly confers jurisdiction to a tribunal. They are called superior court judges, and they are appointed by, again, the federal government. They are courts of inherent jurisdiction, and that, again, means that their jurisdiction or authority can go beyond that which is specifically granted by federal or provincial statute. Provincial courts are a lower level of court to the superior courts. They try most criminal offenses and smaller civil cases. They may also include specialized divisions, for example, youth court, domestic violence court, small claims, etc., and their judges are appointed by the provincial governments. There are also provincial administrative tribunals, for example, labor relations, human rights, municipal government boards. These are empowered by statute, held to administrative law principles, which can be reviewable by the courts to ensure fair proceedings. On the right-hand side of this diagram, we have the federal court system, where the Federal Court of Appeal, again, is the highest court on that side underneath the Supreme Court. And the federal court specializes in areas such as intellectual property, maritime law, federal-provincial disputes, tax courts, the tax court, of course, dealing with those areas of tax law. The tribunals listed underneath the federal court are not courts, but they do play a very important role in Canada's adjudication system, and accordingly shouldn't be omitted from this kind of an overview. There are also some special kinds of entities that are not reflected here, such as, for example, unified family courts, the use of sentencing circles, and others, but this is a general overview of the court structure in Canada. One of the reasons it's really important to understand the court structure in Canada is that it is key to understanding precedent, and precedent is how the common law develops. The decisions of superior courts, higher level courts, bind lower courts in that jurisdiction. So, for example, the Supreme Court of Canada, as you'll recall from the previous slide, is the highest level of court in the country. That means its decisions are binding on every other court in Canada. So if the Supreme Court of Canada issues a decision, for example, with regard to a particular piece of legislation, that decision must be followed by all lower courts in the country. Similarly, the superior trial level courts in a particular province bind lower courts in that province as to the decisions of the Court of Appeal. So in Saskatchewan, if the Saskatchewan Court of Appeal issues a decision on a particular point of law, that decision is binding on the Saskatchewan Court of Queen's Bench as well as judges of the provincial court. Courts of different levels from different jurisdictions across the country may have decisions that are persuasive to other courts, but they do not bind them in the same manner. Also, it's important to note that our courts may look to other jurisdictions, particularly if they are faced with a novel question of law that has not been addressed in Canada. They may look to our neighbours, for example, in the United Kingdom or the United States, to see how courts there have addressed similar points. They will not be bound by those decisions. That means they're not required to follow them, but they may be influential. There are a number of different sources of law that may guide judicial decision-making. For example, there is statute. Statute refers to laws that are enacted by the government, perhaps federal, provincial, territorial, and courts are often called to look to, interpret, and apply legislation. There's also the common law, which is judge-made law. The common law is the body of law that has emerged over time through the decisions of the courts. It's not written down in statute or regulation or code, but rather is based on precedent, which I've already spoken to, and is determined by following a history of court decisions. There are some times where common law principles and statutory provisions may conflict, and in that case, the principle of legislative supremacy applies. And the principle of legislative supremacy states that when a rule of common law and statutory provision conflict, the statute prevails because it is an act of a democratically elected assembly. You do have to keep in mind that legislation remains accountable to the courts insofar as it must be constitutional and is subject perhaps to constitutional challenges if there is an individual or party who feels that it is not. And also there's a very practical element that legislation does not interpret itself, and the courts are often again called to interpret the meaning of legislation in a particular case, and when they do so, it is said to be judicially considered, and that interpretation holds considerable influence going forward in terms of the meaning ascribed to that particular piece of legislation. Civil law systems are a separate system from common law, and they are followed by Quebec in Canada, which has its origins historically in Roman law and more recently in French law. Quebec's civil code is essentially a comprehensive compilation of the legal rules in the province. Previous court decisions are still relevant, but they are generally referred to after the code and to help ensure consistency in its application, but they do not carry the same power that they do in a common law system. The coexistence of both common law and civil law traditions in Canada is known as bijuralism, and we are somewhat unique in that regard because most jurisdictions are either common law or civil law jurisdictions in the world. People are sometimes confused by the term civil law because it can have a couple of different meanings in the legal context. There is the civil law versus common law distinction that I've just spoken to, where we're referring to civil law as a code-based approach, such as Quebec's, versus that in the rest of Canada, which is guided more heavily by precedent. There's also the distinction between civil law and criminal law, and in that context, civil law is referring to private law issues. For example, where someone is suing someone or being sued under contract law or tort or property, versus criminal law, where an individual is being prosecuted by the state. Finally, equity is another form of judge-made law, but is emerged out of a separate historical tradition from the common law. Essentially, it authorizes judges to depart from some legal rules to meet the requirements of justice in a particular case. Now, in the English tradition, there were two separate courts, originally common law courts and the courts of chancery, which comprised the courts of equity. These were merged, however, in 1875 by the Judicature Act, and Canada has followed this tradition. Today, all of the superior courts in Canada are courts of both law and equity. So we have both of those systems and historical traditions of law again operating in our country. These are just a few examples, and this has been a very brief overview, but I hope it provides some useful background for you as you continue on in your studies, looking at the relationship of the courts and other branches of government in Canada.